This case in Manhattan, let's pretend we had a real judge who was competent and who actually wanted to do what a judge is supposed to do. And let's pretend we have this prosecutor, Alvin Bragg, and he files a 34-count indictment against a former president who's running for president again. And let's say the president's lawyers file, as they did, responses to the indictments, seeking dismissal, summary judgment. And let's pretend I'm at this hearing, that I'm the judge, and Mr. Bragg has to present not his case, but I want to deal with this issue of dismissal or potentially summary judgment. Mr. Bragg stands before me and I say, Mr. Bragg, I have read your 34 charges. I'm a little confused. Yes, Your Honor, what might it be? What is the crime that you're alleging? Well, Your Honor, we are alleging that the misdemeanor statutes in New York were violated with respect to the reporting of businesses, and that Donald Trump concealed a payment to Stormy Daniels in a non-disclosure arrangement, hush money, in order to violate the Federal Election Commission laws with respect to positive information in an election that's illegally paid for. Well, that's interesting, Mr. Bragg. I have a couple of questions for you, yes. Now, this misdemeanor statute you're looking at, it's already expired. The statute of limitations are over. They've been over years ago. Yes, Your Honor, but this revives it. Well, I have a question. So why did you bring the case now? It's number one, Mr. Bragg. Number two, you don't get to come into this courtroom, base a case on a federal offense that has never been charged, let alone adjudicated. It's never been charged at the federal level with the Federal Election Commission, referring it to the Department of Justice. It's never been charged by the U.S. Attorney's Office. In fact, both of those entities looked at it and took a pass. So you're asking me, a judge, to take your 34 charges to resuscitate a misdemeanor statute that lapsed years ago because now you decide to bring the case now in the middle of an election, and you claim it's resuscitated and it becomes a felony for which Mr. Trump can serve decades in prison because you have decided, a local elected DA, not the U.S. Attorney's Office, not the Department of Justice, you have decided that Donald Trump committed a federal campaign violation for which he's never been charged, let alone has the matter been adjudicated. Do I have that about right, Mr. Bragg? Yes, you do, Your Honor. You have that about right. Let's go on. Mr. Bragg, what kind of case do you intend to bring in front of me? What kind of arguments? What kind of motions? In other words, where are you trying to take this court? Well, Your Honor, we want to bring individuals in who can tell a story about Mr. Trump's past practices. We need to bring in the National Enquirer to show that payments were made to hush Stormy Daniels and others. We need to bring in Michael Cohen, who made the... Mr. Bragg, yes. Sounds to me like this is highly speculative and political. Have you ever heard of the collateral evidence problem? What is that? Have any of you in the audience? No, because all these great legal minds haven't told you about it. Collateral evidence cannot be admitted because of a lot of reasons. Number one, the propensity to commit wrongdoing is not considered probative. As a matter of fact, it's considered prejudicial to the defendant. You can't bring in the person's life stories or their litigation history or anything else. You got a case in front of you, and the case being tried is the case in front of you, the facts and the law in front of you. You're the judge, that's the jury. This isn't Mr. Trump, this is your life. And yet that's exactly what's taking place in this courtroom. So this judge should have dismissed this case immediately. Immediately. Let me ask you folks a question. Put yourself in President Trump's shoes. You're charged with 34 counts. You were indicted. You can go to prison, and you're not exactly sure what you're charged with. If this isn't a violation of due process, there is no violation of due process. It is impossible for you to defend yourself or for your lawyers to defend yourself in any effective way if you're playing whack-a-mole. Well, maybe they mean this. Well, maybe they're going to charge with this. Or maybe the argument's over here. And I got to deal with this witness over here. And what happened 13 years ago with a money payment over here? Do you understand? You have a right to know with specificity, with detail, what it is that you're accused of. Number two, the accusing party, the district attorney, has to have the jurisdiction. He has no federal jurisdiction to make allegations about federal election laws. That's number two. Number three, there are no allegations. There are no charges. There is no adjudication that Donald Trump violated any federal law respecting the election. So this whole case is a dead case walking. The problem is that won't be realized until appeal, should there be a conviction on one of 34 counts. The overcharging is absolutely outrageous, which is another thing I would have said to Mr. Bragg as a judge. Mr. Bragg, why are you breaking this into 34 individual charges? At best here you have 1, 2, maybe 3. This is called overcharging. I'm not going to allow this to happen in my courtroom. So if you had a real judge, he would have dismissed this case. He would have said, I'm sorry, the statute of limitations has run. You brought the case very late in the middle of an election. You're demanding that I take up the case in the middle of an election, which really is a mistake. I'm not going to do that. In fact, it's abhorrent. Number three, you're arguing that there's another law that breathes life back into the expired misdemeanor statute and raises the level to a felony without any evidence other than your say-so. In fact, the evidence is contrary. The Fed said no. And you expect me to hold a trial here in the course of this? And then in terms of witnesses, you expect me to agree to a long list of your witnesses that have nothing to do with what I believe to be your charges and what I believe to be you're alleging in this case? Do you understand that due process applies to the states under the 5th and the 14th Amendments? That is, to this courtroom? And it is my job to ensure that the Constitution of the United States is upheld with respect to the Bill of Rights, even in a state courtroom? The Biden administration involvement is grotesque, and it is obvious. You've heard about this man who was the number 3 man at the Department of Justice, Associate Deputy Attorney General of the United States. That is a big damn job. And he was the acting Associate Deputy Attorney General of the United States appointed by Joe Biden under Merrick Garland. He leaves this prestigious post to work with Letitia James on her case against Donald Trump. Here we have a case against Donald Trump that alleges fraud without fraud. Just as we have this Bragg case that alleges crimes, if we can figure them out, where there's no crimes. Fraud where there's no fraud, crimes where there's no crimes. And so who is behind all this? Well, in part, it's the number 3 guy, the Biden guy. He helps Letitia James, then he moves to help Alvin Bragg. He's a very busy man, so he goes from this prestigious federal position into Attorney General's office, and then to a lower office, a DA's office, and we're all supposed to pretend he's just a good Samaritan lawyer, that's all. No, he's there representing the Biden regime in their effort to destroy Donald Trump and imprison him before this election. That is exactly what's going on. Now, let me make something abundantly clear about all of this. There is a recent Supreme Court decision. They don't call it the Supreme Court. In New York, it's kind of weird, but it's their highest court in New York that just threw out the Harvey Weinstein conviction. The Harvey Weinstein conviction of 2020. Now, why did they throw that case out? Do you know why they threw that case out? Because of the collateral evidence rule. That is, the court said in so many words, you know what? You allowed all kinds of witness testimony and evidence in that had nothing to do with the allegations that were made in the indictment in front of the trial court. And that is destructive to due process. It's not probative. It undermines the defense's ability to defend themselves. That is, the lawyers and the defendant. So they threw it out. They'll do exactly the same thing with this case. The problem is it won't happen likely until after the election. Should this jury in this dark blue Democrat city, the same people who elected Alvin Bragg elected this judge. It's the same constituents. It's the same place, Manhattan. But it won't be until, if something happens, God forbid, and he's convicted of something, it won't be until after the election that the actual adjudication will occur. This is a farce beyond even my ability to describe it. It's clearly an effort to interfere with this election by the lawyers, by the prosecutors, and by the judges in New York City. By the lawyers and the prosecutors in Albany, New York. This is a disgusting disgrace, and I hope the justices on the Supreme Court who've been sucked into this Jack Smith argument about, well, is it official or private? Is it a private action or official action? Understand that what you have here is the criminalization of politics, the criminalization of the electoral system by the system. That the law is being abused. This is not justice. It is the law that is being abused. It is being abused in Manhattan. It's being abused in Fulton County. And it's being abused in Washington, D.C., by a rogue prosecutor by the name of Jack Smith, who had to be admonished by the Supreme Court 8-0 in the Bob McDonnell case, the Republican governor of Virginia, but even then it was too late by the time it got to the Supreme Court. This is sleazy, contemptible, diabolical, evil lawfare. And everybody knows it, except for the paid grifters, the former so-called federal prosecutors and defense lawyers, these slip-and-fall ambulance chasers on MSNBC and on CNN. Everybody else knows what I'm telling you is true, that this case should have been dismissed on the law for a lack of a crime, right up front, but it wasn't. And so there's Donald Trump. And even to give you a little piece of this, he keeps saying the courtroom is very, very cold. Why is the judge keeping the courtroom very, very cold? It's to make Donald Trump uncomfortable. That's all. Why did the judge rule that rather than taking off on Fridays, we'll take off on Wednesdays? Why? Because Orthodox Jews, they celebrate the Sabbath when the sun goes down on Friday. And they are among Donald Trump's biggest supporters in New York. So he didn't want them on the jury. And I can go on and on and on about what's taking place here. Every one of the people involved in this should be disbarred. Every one of them. But it won't happen. You know why? Because the New York State and the New York City bars are part of the election interference. There's parties first. Justice is way down the list.
Want to see more Mark Levin? Go to LevinTV.com and subscribe now.